Hear from the appellant when you're ready.
Good morning, Your Honors.
Good morning.
May it please the Court, C. Christopher Raines III for the appellants Michael and Aaron Centel. May I reserve 5 minutes for rebuttal, please?
That'll be fine.
Thank you, Your Honor. In this termination of parental rights case, we raise 4 primary issues presented in our brief. For brevity purposes, I'm going to focus on primarily our assertion that mother failed to raise the affirmative defense of willfulness. We alleged 3 grounds to terminate her parental rights: abandonment by failure to visit, abandonment by failure to support, and a failure to manifest an ability to assume physical, legal, or financial responsibility. And I would submit in this case there's essentially a threshold question from our perspective regarding the defense of willfulness, and that would be if the mother failed to raise the affirmative defense of willfulness through a pleading or at trial, isn't essentially the trial court statutorily prevented from ruling that mother's conduct was not in fact willful. The evidence is uncontroverted that mother did not plead willfulness as an affirmative defense. She nor her counsel sought to amend any pleadings, and the defense of willfulness was not raised at trial by the mother. TCA 36-1-1021I makes it clear that the parent has the burden of proof to show their conduct was not willful. And I would suggest that such a finding cannot be conferred upon a party who has not pled the defense. Once TCA 36-1-1021I was changed from essentially an offensive burden of proof to an affirmative defense raised by the respondent. Once that occurred, willfulness became an affirmative defense under Tennessee Rule Civil Procedure 803. Affirmative defenses must be pled or they are waived. In our case, the trial court did not find that the appellants failed to meet their burden of proof, rather that mother's failures to visit or support during the determinative time period were not willful. With the utmost respect to the trial court, we submit that inference that mother's conduct was not willful without raising the affirmative defense, raising it at trial or in a pleading, was an abuse of discretion. Further, the evidence presented does not support a finding that there was a lack of willfulness as to the grounds for failure to support or visit. Failure to visit or support is willful where a person is aware of the duty to visit or support, they have the capacity to do so, there's no attempts made, and there's not a justifiable excuse for their failures. Conduct is willful if it's a product of free will, not coercion. A person acts willfully if they know that what they are doing and intends to do so. So in this case, mother's supposed belief that there was a no contact order or she couldn't see the children is not sufficient enough absent significant restraint, interference from father, guardian of the children. And that
Can you explain to me a little bit about the order, this mystery order that was in question? Was it something, it's not signed, was it something that was proffered and just not signed? What happened with that?
I can. It was it was introduced for identification purposes only. I had thought it was entered. That was what the previous trial judge, Chancellor Moody, had ordered. I think subsequently there was a motion to set the order aside, so it was not entered, and that's why it was marked for identification purposes only, and I said that in the trial transcript. So,
wasn't there something written on a jacket or something to that effect by the judge about some direction to the mother? Or
The trial judge, the first trial judge ordered that she had to, he announced in court that she had to appear before he would change her visitation. I'm not sure if that answers your question, but.
I saw it somewhere, again, I've read the briefs, I haven't read the entire record. So I recall there being some notation or something from the judge, but nothing entered as an order.
There was none, and that's why it was marked at trial for identification purposes only. There was no representation that was signed.
And was there ever a hearing on this motion then to set aside this order that was never actually signed?
No.
But mom's testimony is that her lawyer told her she was under a no contact. Is that right?
That is her
Okay.
argument, yes. And that would have happened, I believe, in January of 2022. So, I'm skipping ahead slightly, but if you're looking at the urgency in terms of the best interest factors, I believe it's O or P, take some action. This is January of 2022. So, we would submit the evidence is pretty uncontroverted that during the determinative time period, which was stipulated from January 27th of 2024 through May of 2024, mother admitted at trial that she provided no financial support to the appellants despite having a job during that time period. She knew she had a moral obligation to support the children. Knew the children had financial needs and that she failed to address those financial needs despite having employment. Our guardian ad litem took the position that the mother failed to financially support the minor children. During the determinative time period, she admitted that she purchased alcohol for herself. She admitted that she had no parenting time during the determinative time period and that she had not requested through the party's messaging app, Our Family Wizard, to ask for parenting time. So her admittance of those facts at trial are uncontroverted. We also raised the third ground of failure of mother to manifest an ability or a willingness to assume responsibility. And that's essentially a two-prong analysis, with the first one being if you prove there's a failure to either manifest an ability or a willingness, you've satisfied the first prong. And the second would be substantial harm, potential substantial harm. I think our guardian ad litem said it best, and I quote him, trial record 212, but I don't see how it is in the best interest for these kids at this point. We're talking about basically 2019 until now, which is 5 years, of which is, half these kids' lives. They've had no mom in them, and now we're supposed to throw mom back in here and say that it's all fine when she admits she's still drinking.
Well, at some point, she did resume Zoom visitation. Is that right?
Yes, it was granted by
And
the trial court.
When was that?
It was sometime spring, perhaps of this year.
Before or after the petition was filed?
After.
After. So she didn't resume visitation after the petition was filed?
Not on any kind of regular basis. She may have had previously around the holiday a Zoom interaction. I apologize, I don't have the specific date, but no, nothing after on a consistent basis.
Okay, and is there testimony in the trial court about why she did what before or after the petition was filed? And I know that's a very broad question.
In terms of testimony from?
From the mother.
She did testify, yes. I'm sorry, could you repeat the part of it?
I think what I remember from and again, I haven't read everything, was that the petition maybe triggered her to know what she needed to be doing or something to that effect. And I was asking you about what her testimony said in that regard.
I believe she said that she had realized there was no contact sometime around May or June of 2024, which would have been around the same time period that our petition was filed. So yes, I think that's what I believe you're referencing.
That's what I was getting at.
Yes,
Thank you.
yes. So again, 3 grounds alleged primarily. We believe the evidence supports all of them. We also submit that the best interest factors highly favor the appellants, the father, and the stepmother. Thank you.
You have your time for rebuttal. We'll hear from the appellee.
I'm Ed Kershaw from the Greene County Board. It's my pleasure to be here. First of all, I want to address a question that Judge Smith had asked, kind of finding a needle in a haystack with that question, but you found the needle in the haystack. The needle in the haystack was the judge did reference that there was a notation in the jacket of the file where the previous judge had said something. And what I'm going to call the mystery order did not match what that jacket said. So there was a notation in the jacket. The mystery order did not match what the notation in the jacket said. I don't know how you found that, but that's a good question. The first issue that's been raised, I believe, is the affirmative defense. And in my brief, I put out pretty clearly the statute and some case law. You don't have to use the word affirmative defense to raise an affirmative defense. There's no requirement in the rule that you use the word affirmative defense. The word affirmative defense was not used. Mother did a pro se answer, but she raised the affirmative defense. I'll go a step further. I don't believe you actually have to call a complaint or a petition. I think you could call it a request, but if it's got the appropriate verbiage, it's still considered a complaint or a petition. In Mother's answer, the very first paragraph, literally the very first paragraph to her answer says, quote, "My former attorney, Lois Schultz Davis, with Schultz Law Offices located at 111 Gay Street, Irwin, Tennessee, 37650, in a meeting on or around Friday, January 14th, 2022, Ms. Schultz Davis informed me in the presence of my mother, Christina Joyce Zimmerman, that I was under a no contact order indefinitely or until a court action was taken." Now, what's bad about this no contact order, and it's not just the first paragraph. I've only read the first paragraph to you. The next few paragraphs, she raises the same affirmative defense. She just doesn't use the word affirmative defense.
What about the failure to support?
So, on the failure to support, the parents had a plan in place. They still have a plan in place. And what I would submit to this court is, while we follow permanent parenting plan orders, the truth is the practicality of real life is most parents don't, and most judges don't expect them to. And let me just give you an example. If dad gets visitation from Friday at 6 to Sunday at 6, and dad calls ex-wife and says, "Hey, I'm available at 4. Is it okay if I pick up the kids at 4? And ex-wife says, "Yes, pick up the kids at 4. Judges aren't going to say you're in contempt because it says 6. They're going to encourage the visitation. To answer your question, the parties had an agreement. In 2016, they did a 50-50 child support a 50-50 parentage arrangement, and the judge didn't order any child support at that time. That is still in place.
Well, does that matter, the fact that, in the case law, pretty clear that there doesn't have to be an order ordering the parent to pay child support?
You're correct, except in this case, you will note that the parents agreed. So what they did is they agreed that she could go to Nashville temporarily and that they would follow the same parenting plan.
I don't understand, though, as to support. What was the plan?
The plan was for her to go to Nashville, try to get a job and get on her feet, and then to start resuming support.
And she did get a job and get on her feet.
Eventually, she got a job and
And
got
did
on
she
her
pay
feet.
anything then?
She was buying some items, and then she, through me, filed a motion to start paying. We asked the judge, there was no child support amount in place.
I understand there was no order.
But the
I'm
answer.
trying to figure out, she said she went to rehab that last time and that it's taken. She's working, making a good salary, good home. When did those things happen? When did she, in other words, when did she start, get on her feet, as I think as you put it?
I want to say 2022 is
And that
when
would be
she,
where in the process?
I think the petition was filed in 2021, but I would have to
All
pull it
right.
out.
Did
to
she
see.
start paying support then?
She did not start paying child support when the petition was filed. In answer to your question, her position was she didn't think she had to because
I understand that's
they
her-
had reached an agreement.
You keep saying they'd reached an agreement to do what? For her not to pay child support?
Yes.
And that's what the trial court found, apparently.
Yes. Yes, and in fact, Mr. Centel testified, he said, I was in agreement with that she wasn't going to pay child support, that she was going to go to Nashville, but that the goal was for her to get back to East Tennessee. She didn't want to stay in Nashville. She just couldn't get a job as a controller in the Kingsport area at the time. She was able, after a while, she was out of work for a considerable period. That was part of the testimony. She didn't have a job for a considerable period. And then she did get a job, and then she left that job and she came back to Kingsport. During that entire time frame, there was no order to pay support. But not only that, they had agreed that she didn't have to pay support. Now, whether they
Even
could
after
agree or
she-
not,
I'm sorry, even after she got their agreement was that even after she got a job, she didn't have to pay child support?
correct. The goal was to get back to 50-50. The goal was to get her back from Nashville to Kingsport to resume the 50-50. But what happened in the interim is she had some drinking issues, and then father changed his goal, and his goal was no longer to have her have 50-50, but no petition was ever filed by father to not have her have 50-50. But the goal all along, until mother had the drinking episodes, was that she would go to Nashville temporarily, work temporarily as a controller, then come back to Kingsport, and they would keep doing the 50-50. The other argument, go ahead, Your Honor, I don't mean to interrupt you.
No, that's fine. You say continue doing the 50-50. What was supposed to be 50-50?
So it was in a 14-day period, each of them
Yeah,
had 7
we're talking
nights.
about time with the child. So what was was Fifth supposed to get back to 50-50? So what was the agreement as far as support? I'm just trying to find it. The court found exactly
Are
what
you
you
talking
said.
about in the 2016 child support parenting plan?
No, I'm talking about the related to the ground of failure to support.
Yes, Your Honor.
The trial court found they had an agreement, apparently not to basically formed their own plan together. So I'm trying to find out what was this plan as far as support, not as 50-50 with the child, but as far as support.
Okay, the plan was that she would not pay support. The plan was that she would visit whenever they could work out while she was in Nashville. And the plan was that she would come back from Nashville and once she got a job in Kingsport, and they would go back to 50-50. So the idea was for a brief interval, they would just have to agree on visitation. They weren't following the parenting plan that had been signed by the judge.
Again, I'm not talking about visitation, I'm talking about support.
So the
What was
plan,
what was the plan?
was not to pay support.
Ever?
Ever. Yeah, the goal was for her to come back, resume 50-50, and never pay support. That's still our goal. It's still the goal to get 50-50. And, well, our position is, as we sit here today, that 50-50 plan's in effect right now. The judge has never actually set aside the 50-50 plan. So what's in effect as we sit here right now is a plan that says the parents each have 50/50 and no child support is ordered, which is in contravention of the termination order that does order child support, which she is paying. So we've kind of got two conflicting plans in place right now. We've got the 2016 parenting plan that's never been set aside that says 50/50, no support. And then we've got this termination order that's in front of the court today. And that termination order starts giving her more and more visitation. She's getting overnights right now. And it orders her to pay a specific child support amount, which she has been paying. The other thing I would note to the court is that the motion that was filed to pay child support was filed by mother. It was not filed by the father. So mother came along and mother filed a motion and said, I'm being accused of not paying support. Nobody has told me what to pay. I'd like to start paying. So at that point, she retained me. I filed a motion and said, what should she be paying child support since there's already a plan in place? And if so, what is the amount that she should pay? And as a result of me filing a motion saying, hey, there's this plan that says no child support, mother wants to pay child support, what should she pay, is how we ended up with an amount to get her paying child support, and she's paying child support currently. The one thing that I haven't really addressed is this no contact order. And it was briefly mentioned by Mr. Raines. It wasn't just mother. At trial, it came out that it wasn't just mother that thought there was a no contact order. It appeared that Mr. Raines thought there was a no contact order. When he tried to introduce the order, he introduced it as being signed. He told the judge, I've got a signed copy. Mrs. Centel, the father's new wife, who is a party to this case, she wouldn't let have mother visitation on one occasion. She wouldn't let have mother because she said there was a no contact order in place. There was testimony that mother was supposed to have Zoom visits that were stopped because of a non-existent no contact order. So she stopped having Zoom visitations because of a non-existent no contact order. So a lot of things happened to her because of a non-existent no contact order. And at trial, it very much seemed that the appellants were of the belief, even at trial, that there was still a no contact order. And I even mentioned in my brief that in their brief at one point they referred to the non-existent order as being signed. And I mentioned that in my brief, that it surprised me that even in their brief before you guys, they referred to it as being signed when it's never been signed. And that no contact order prevented her from seeing her kids for a considerable period of time that never existed and was never signed. I believe I've made the arguments that I need. If you have any questions, I will address them. Otherwise, it's been my pleasure.
I hear none. Thank you. We'll hear from the appellant in rebuttal.
In my summation of the statement of facts, I did state that that is what Chancellor Moody ruled. I did not state that the order had been signed by the court. That's not in writing anywhere in my brief, just to clarify that. I again view this as almost a too little, too late. You can't have it one way, have it both ways. If the goal is to come back here and you accept that premise, to come back to East Tennessee after being in Nashville and get back on your feet and get a job, then years went by and that did not occur. Again, it goes back to the threshold question of willfulness. What is that definition? Is the proof sufficient to give mother that affirmative defense? Was she in jail? Was she in a long-term rehab constantly? No. She was in and out of rehab multiple times. She had employment. So I think that is almost kind of goes against the spirit of what you generally see in termination cases where someone says, well, this wasn't willful because I was here. This is a parent that got married, that put down $18,000 approximately in cash on a house rather than paying child support, says, I filed a motion to pay child support. Well, when are you going to start? Certainly don't want to condemn or I will commend her progress in her own self betterment, but it's just too little too late for these children. It was acknowledged by the guardian, clearly supporting the termination. And we believe we have, if you take away the willfulness, affirmative defense, or even if you applied it, the facts that mother admitted to for failing to visit, failing to support, stating that she knew during the determined time period that the kids needed things and that she couldn't provide them, we would assert that we've proven one of those grounds, at least one. And then if you review our brief and the application of the best interest factors, they weigh heavily in favor of these, of the appellants who have essentially solely raised the children for the last 5 years. Thank you.
Thank you. Our thanks to both counsel. We appreciate your oral arguments today and your briefs on this. Have a good rest of the day. If you would, recess court till 1:30 this afternoon.
All rise.